You have the right to remain silent.
You have the right to remain silent.
He has the right to remain silent.
You may have heard this phrase being said many times before. This is what police officers have to say when they arrest someone, informing the convict of their rights. The full saying goes, "You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I have just read to you? With these rights in mind, do you wish to speak to me?" This was not something the police always had to do, and the origin of it comes from the 1966 Supreme Court case of Miranda versus Arizona. The year was 1963, and Ernesto Miranda was arrested on the suspicion of theft from a local bank. The police brought him in for questioning, and after 2 hours, Miranda confessed to the theft and also to a kidnapping of an 18-year-old woman, and the woman selected him as a criminal in the lineup of 4 suspects. He was then taken to court and charged with both rape and kidnapping and sentenced to 20 years in prison. However, the police had not informed Miranda of his rights to remain silent or to have the counsel of a lawyer. Miranda then appealed to the Arizona Supreme Court about this, saying that his confession was unconstitutionally obtained by the police as a violation of his Fifth Amendment rights.
The Fifth Amendment creates a number of rights relevant to both criminal and civil legal proceedings. In criminal cases, the Fifth Amendment guarantees the right to a grand jury, forbids double jeopardy, and protects against self-incrimination. After the Arizona court upheld this decision, Miranda went to the U.S. Supreme Court. There were 9 justices in the 1966 Supreme Court: Chief Justice Earl Warren, Hugo Black, William O. Douglas, Tom C. Clark, John M. Harlan II, William J. Brennan, Potter Stewart, Byron White, and Aim Fortis, according to the CQ Alamac. Justice White, Black, and Harlan generally held a conservative stance, while Chief Justice Earl Warren, along with Justice Brennan, Douglas, and Fortis, generally adopted a liberal stance. Ernesto entered the case with only an 8th grade education, and his major supporting arguments was Escobedo versus Illinois. For a quick summary, after being arrested and taken into police custody as a suspect in the murder of his brother-in-law, the petitioner asked to speak to his attorney. His attorney arrived at the police headquarters soon after the petitioner did and was not allowed to speak to his client, as the officer said they had not completed questioning. The petitioner also was not warned of his rights to remain silent before the interrogation. He was convicted of murder, and the Supreme Court of Illinois affirmed he was then granted certiorari.
The court also had their arguments, including Miranda had previously been convicted of a crime, Miranda's confession was made by his own free will, and the decision in Escobedo does not apply to this case because the requirement of warnings that would apply in all cases is not found in the Constitution. The Supreme Court reasoned in a 5-4 decision that because the right against self-incrimination is so fundamental and because it is so simple to inform defendants of their rights, any statement made by defendants during a custodial interrogation in which the defendant has not been read their Miranda rights are inadmissible in both state and federal courts. As Chief Justice Warden states, the prosecution may not use statements, whether exculpatory or inculpatory, stemming from custodial interrogation of the defendant, unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. Justice Harlan responded with the main dissent as he argued that the newly created rules did not protect against police brutality, coercion, or other abuses of authority during custodial interrogations, because officers willing to use such illegal tactics and deny their use in court were equally able and destined to lie as skillfully about warnings and waivers. Instead, he predicted that the new requirements would impair and substantially frustrate police officers in the use of techniques that had long been considered appropriate and even necessary, thus reducing the number of confessions police would be able to obtain. He concluded that the harmful effects of crime on society were too great to call the new rules anything but a hazardous experimentation.
Before Miranda versus Arizona, law enforcement wasn't required to read these rights to people being arrested. This is why these rights are often referred to as the Miranda rights. Although some critics feel that mandating these warnings was a federal intrusion on the rights of states, the result of this case has helped many people being arrested and interrogated be aware of their rights. Since Miranda versus Arizona, there have been many more cases that were defined based on if the Miranda rights were read to the person being arrested. This case and these rights have made their way into pop culture, with many references to the famous line, "You have the right to remain silent." The use of this phrase has been seen in shows such as The Wire, The Shield, Hill Street Blues, NYPD Blue, Cops, and even in international media. To add some more details about Miranda himself, after his case was overturned by the Supreme Court, he was retried, where his unconstitutional confession was omitted. He was still found guilty and went to prison for 11 years before being paroled in 1972. After his release, he made money by selling Miranda rights cards with his signature on it. His life ended by getting stabbed in a bar fight. This case had a very large impact on America because most people would be unaware that they have the right to not answer questions and to ask for a lawyer, and informing them of this right helps them to actually use it. Overall, this case was very important because we believe that suspects should have their Fifth Amendment rights read to them.